So in law, traditionally, a personal budget has really just been a direct payment. And for children, that's a social care payment, where under Section 17A of the Children Act, 1989, the local authority can give money to the family to enable services to be purchased rather than providing the service directly. And of course, in many areas, that's now the main way in which social care support is provided to disabled children. It is important to bear in mind, though, that it's never been a requirement for families to have a direct payment. It should always be an option or a choice. And families can choose not to have a direct payment if they don't want to manage the money themselves, or if for any reason they're not able to manage the money themselves. There's always a right instead to have the service provided to meet the assessed needs. There's been a long-standing intention to expand personal budgets to include other areas of funding, whether that's welfare benefits or health funding, for example, or education funding. And certainly very many areas are now at least piloting health personal budgets so that NHS money can be added to a direct payment from social care, perhaps, and a personal budget pooling that money can be used. The other big area of development is potentially education funding. And that's where the New Children and Families Bill may change things, because at the moment you can't make an education personal budget, but when the bill goes through, then you will be able to, and certain services will be able to be bought. Education services, therapy services, for example, families will be able to buy those using a personal budget rather than just receiving the service from the school or the local authority. In terms of the new education personal budgets, one big issue is going to be when is the child entitled to a personal budget, if the family choose that, or when are they going to just have to have the service provided by the local authority. And certainly in the pilot areas that I've been looking at, it's only been, you've only had a right to the personal budget where there isn't already a block contract or some other way in which the service is being commissioned by the local authority, because for the good reason that it's not sensible for things to be paid for twice. So where, for example, speech and language therapy is already commissioned on a block contract basis, it may be that the family can't get the funding for speech and language therapy through the personal budget. So that's going to be a really important issue to look out for as the bill goes through Parliament. What's the test for when the right to the education personal budget kicks in? In terms of how forums can influence direct payments, personal budgets, it's really very much, in my view, part of the work that forums should be doing generally with the local authority. So if there are policies around direct payments, access to direct payments, direct payment rates, for example, which are detrimental to children and families, then the forum should be using the channels they have with the lead member for children's services, with the director of children's services, or with the other officers of the authority to raise those concerns. If that isn't working, if those discussions aren't taking place or aren't leading anywhere, then those are all issues that are subject to legal challenge as well, and where families could potentially bring a judicial review. But certainly in the first instance, there should be discussions between the local authority and the parent forum to try and resolve any problems that may arise in relation to direct payments. One of the key legal issues around direct payments or personal budgets is how much money is going to be given. And the duty, certainly in relation to social care, is to meet the reasonable cost of securing the necessary service. And that comes from Section 57 of the Health and Social Care Act 2001. So the duty for the local authority is to pay whatever is a reasonable cost, so that's a question for the local authority at least at first, of buying the services that the child needs. And the only way they will be able to know whether that's happening is from the assessment. What does the assessment say is necessary? And then is the amount of money reasonably sufficient to meet needs? So that's the core legal duty. And for example, any set direct payment rate, a fixed rate, which is always paid per hour by way of direct payments, that may well be unlawful, because it may well be that in some cases that's not enough to actually meet the child's needs if the child has particularly complex needs. So there always has to be a connection between the assessment of need and the amount of direct payment or personal budget that is being made available. Some local authorities are using systems that might be called resource allocation schemes, or RASs, to try and calculate the amount of personal budgets or direct payments. And the Supreme Court looked at that issue in a case I was involved in called KM and Cambridgeshire. And what the Supreme Court said in KM was that it was fine to use a RAS as a starting point, as a way to get an indicative amount of money that might be reasonably sufficient to meet the needs, but that in every case the duty on the local authority was to actually make sure that needs are met. So if a RAS is being used and the sum of money is just going to be whatever the RAS says, that's highly likely to be unlawful. If it's being used to start the conversation about the amount of money that's going to be needed, and then it can be changed up or down to reflect the actual needs, then that's likely to be fine. So if local authorities are using RASs, they need to make sure they're using them in a way that respects the judgment of the Supreme Court in KM, and parent forums can hold local authorities to account in that respect.